Afternoon. We selected the jury this morning. The state has provided preliminary jury instructions for the start of the case. The state shared those with the defense, correct? Obviously, given the situation yesterday, I'm only going to read the initial instruction on the one count, but other than that, they seem to be in order. They're pretty much pro forma. Burden of proof, presumption of innocence, some of the basics at the start of a case, including the preliminary instruction, evidence, circumstantial evidence, transcripts. Defense have any objection to those instructions? No, Your Honor. All right, then I plan to bring the jury in. The jury will be sworn in as soon as they're brought in. I will say, as we're getting started, as we're on the record for the people in the gallery, this statement is going to be made one time. You're allowed to be in the courtroom as long as you can behave and conduct yourself appropriately, which means no talking, no kibitzing, no cameras, no phones, and no coming and going. If there are violations of the decorum of this court, they'll be dealt with by the Sheriff's Department, which will probably mean you will be excused, regardless of your interest in this case. That applies to anybody with either side. It applies to the media. It applies to everyone that's in the courtroom. I expect decorum today and through the duration of this trial. All right, we'll have the jury brought in. I'll read them the preliminary instructions. Both sides can make opening statements. I would ask and expect that the opening statements are relatively succinct, and then we'll start with the state's first witness. Everybody can remain seated when the jury comes in. All right, if the jury can stand and raise your right hand, please, so you can be sworn in. Welcome back, ladies and gentlemen. Let's try that again. Welcome back, everybody. As I said before lunch, as the jury in this case, I'm going to read you the preliminary jury instructions. During voir dire, both sides discussed on multiple occasions the law that's going to be given to you by the court. This is one of those instances. These instructions at the start of the case are relatively short. You'll receive similar instructions at the end of the case in a few days, whether that's Friday or Monday. You'll receive similar instructions. I would ask that you pay attention to the instructions. After I read you the instructions, both sides will make opening statements, and then we'll start with testimony. Ladies and gentlemen, before the trial begins, there are certain instructions that you should have to better understand your functions as a juror and how you should and must conduct yourself during the trial. Your duty is to decide this case based only on the evidence presented and the law given to you by the court. You are not to let any personal feelings of bias or prejudice about things such as race, religion, national origin, sex, or age affect your deliberations. You are not to begin any deliberations or discussion of this case until all of the evidence is presented and after I have again instructed you on the law. You are not to discuss this case among yourselves or with anyone else until your final deliberations. As you've already seen, we will stop or recess from time to time during the trial. You may be excused from court when it's necessary for me to hear legal arguments or discuss matters with the attorneys. If, during the trial, you come in contact with parties, lawyers, witnesses, you are not to speak to them, and they are not to speak to you. As I've also already said, you are not to listen to any conversations about this case. Please do not read any newspaper reports or listen to or watch any reports on radio or TV about this trial. You are not to investigate this case on your own or to visit the scene. You are not to engage in any experiments or research relating to any issues, facts, or persons involved in this case. As you've already also heard, you are not to consult dictionaries, computers, websites, or other reference materials for additional information. Anything you may see or hear outside of court is not evidence. You are to decide this case solely and only on the evidence offered and received at trial. Evidence. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who calls a witness. Second, any exhibits the court receives, whether or not an exhibit goes to the jury room. And third, any facts that the lawyers agree to or stipulate to, or which I, as the court, direct you to find. Circumstantial evidence. It is not necessary that every fact be proven directly by a witness or an exhibit. A fact can be proven indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Transcripts. You will not have a copy of the written transcript of trial testimony available for use during your deliberations. That means you need to pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and the testimony that's introduced during the trial. Credibility. It's your duty, the duty of the jury, to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the trial, the witness's conduct, appearance, and demeanor on the stand, the clearness or lack of clearness of a witness's recollection, the opportunity a witness had for observing and knowing the matters testified about, the reasonableness of the witness's testimony, the apparent intelligence of a witness, any bias or prejudice, if any is shown, any possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend to support or discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is not a magic way for you to evaluate testimony. Instead, you need to use your common sense and experience. In everyday life, you determine for yourselves the reliability of things that people say to you, and you should do the same thing here. As you know, in this case, the defendant is charged with first-degree intentional homicide. It's alleged that on or about Tuesday, September 22nd of 2020, at 1750 North Holton Street in Milwaukee, Milwaukee County, the defendant did cause the death of Jason Cleereman, another human being, with the intent to kill that person, contrary to the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the charged offense beyond a reasonable doubt. The definition of the crime: first-degree intentional homicide, as defined in the Wisconsin Criminal Code, is committed by one who causes the death of another human being with the intent to kill that person or another. The burden of proof: before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. The elements are: 1, the defendant caused the death of Jason Cleereman. Cause means that the defendant's act was a substantial factor in producing the death. And 2, the second element, is that the defendant acted with the intent to kill Jason Cleereman. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. Intent. While the law requires that the defendant acted with the intent to kill, it does not require that the intent exist for any particular length of time before the act or action is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. Deciding about intent. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances, in this case, bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not, by itself, establish guilt. You should give it the weight you believe it deserves under all of the circumstances. Your decision, if you're satisfied beyond a reasonable doubt that the defendant caused the death of Jason Cleereman with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. The information in this case alleges not only that the defendant committed the crime of first-degree intentional homicide, but also that the defendant did so while using a dangerous weapon. If you find the defendant guilty, you must then answer an additional question. That question is, did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? Dangerous weapon means a firearm, whether loaded or unloaded. A firearm is a weapon that acts with the force of gunpowder. Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer that question no. The burden of proof. In reaching your verdict, you are to examine the evidence with care and caution. You are to act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless, during your deliberations, you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of proof. the burden of establishing every fact necessary to constitute guilt is on the state. Before you may return a guilty verdict, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. Reasonable doubt. The term reasonable doubt means a doubt based on reason and common sense. It is a doubt for which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or to hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt based on guesswork or speculation. A doubt which arises merely from sympathy or from the fear of returning a guilty verdict is not a reasonable doubt. A reasonable doubt is also not a doubt such as may be used to escape the responsibility of making a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. In just a minute, both sides will make opening statements. The purpose of an opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show so that you will better understand the evidence as it is introduced during the trial. I will caution you, however, that opening statements are not evidence. At this time, I'll ask both sides to make opening statements, starting with the state. Mr. Hubner.